Hello and welcome to a session on jurisprudence, interpretation and general laws. We are going to discuss lesson number 2, that is the Indian Constitution, in today's session. Indian Constitution in itself is a very vast subject. LLB graduates studied this one subject over 1 year, 2 semesters. But as a part of executive program, they've included it as one chapter in the entire JIGL syllabus. So I am going to cover this chapter from the point of view or the syllabus that has been provided by the ICSI material. Now, before going into the actual discussion of today's session, I would like to introduce myself. I am CA Swathi Sharma, faculty at Ekcel Academy. I will be teaching the law subjects. Like I said, Constitution is so vast. If we want to cover the entire chapter, we need a lot of sessions. So, I am going to restrict my session today to one single topic. But before telling you what is the topic for discussion in today's session, I would like to show you one image. Do you know what statue this is? Have you ever seen this before? Do you identify what this is? Yes? So, this is the Lady Justice of India. One is the old version, other one is the new version which was launched in November 2024. You would have seen this in the movies, right? It is there in the courtrooms. But what does this Lady Justice of India signify? Why did we bring about a change? And why am I discussing the Lady Justice in today's session? Why? Because there are a few changes that have been brought about. The old version of Lady Justice of India was adopted long back with the influence of the Britishers and the Roman culture. But now we have decided and adopted the Indian version with the Indian principles. What are the changes that have been brought about? First change is with respect to the attire. The earlier lady version had a western attire, but now we have given the Lady Justice a sari. So that is directly implicating the Indian culture and values. Second change that has been brought about is with respect to the blindfold. The older version of the Lady Justice was blindfolded, that to signify that we are not going to see the status of the parties, we are not going to see the status and give the judgment. There is not going to be any kind of bias, no corruption, absolutely nothing. We are not going to see the parties before giving the judgment. That is the significance of blindfolding. But now in the new version, the blindfold has been removed. We accept the principle that we will go on equality. We will see both the parties. We will treat both the parties equally. We are not closing our eyes. We are seeing the facts. We are treating both the parties on the same footing, that is to implicate equality that is going to be given to both the parties. Third change that has been brought about is with respect to the instrument that has been held in the hand of Lady Justice. Earlier, the Lady Justice had a sword in her hand signifying authority and power to give judgment and punishments. But over the years, there was a thought that sword depicts some kind of violence, so we have to change it. And this is the reason why I am discussing this in today's session, is because now we have replaced the sword with the book of Indian Constitution in the hand of Lady Justice, and that signifies how important this one book or this one subject of Indian Constitution is. The Lady Justice of India is carrying the Indian Constitution book in her hand, signifying that we will abide by the provisions, principles and guidelines that have been given in the Constitution. The constant thing which is not changed is the weighing scale in the hand of the Lady Justice. That signifies that we are going to weigh the evidence of both the parties. Whichever carries more weightage, whichever seems to be true, that party is going to win. So we are going to take the evidence from both the parties. Whichever evidence is reasonable, whichever evidence is acceptable, that party may win. So we are going to decide the cases on the basis of evidence submitted by both the parties. So this is the significance of Lady Justice, and why I have discussed this is merely because now the new Lady Justice is carrying the Indian Constitution book in her hand. That is a huge thing. You should understand the importance and significance of this chapter merely by seeing the Lady Justice carrying this book, right? So it is the law of the country, it is the supreme law of the land the constitution, any other law that has been established or is going to be brought into force in future has to be in compliance with the Indian constitution. If any law is not following the principles given by the Indian constitution, that law itself is going to be deemed to be void, cancelled, not brought into force. That is the power of the Indian constitution. So like I told you, if we discuss the constitution, it can go on for sessions together. So I'm going to limit this session to one topic, that is Article 19 of the Indian Constitution, where I'm going to discuss three things. That is, what are the rights granted under Article 19 of the Indian Constitution, what are the reasonable restrictions that are imposed on the rights that have been granted, and certain case laws, that is judicial interpretations, what were the issues, what was the case, and how did the court interpret the provision of Article 19 in reference to that particular case. So these are the three things that we are going to cover in today's sessions in reference to Article 19 of the Indian Constitution, which is one of the various fundamental rights granted to the citizens. But before going into the discussion on Article 19, I have displayed the preamble. Again, this is not an entire session of discussion on preamble. That itself will require a lot of time. I have just displayed here the preamble to show that through preamble, we have certain objectives set, we have certain goals set that we want to provide to the Indian people, to the Indian citizens. Right? To implement the goals and objectives that we have laid down in the preamble, we have to give certain rights to the people, and these rights are provided to the Indian citizens via the fundamental rights given under Part 3 of the Indian Constitution. We say that the Indian Constitution is given by the people, for the people, and to the people. Right? That is the Constitution. So what are fundamental rights? To implement the aims and objectives of the preamble, it was required that we have to give certain rights to the citizens, and that is laid down by the fundamental rights given under Part 3 of the Indian Constitution. But what are fundamental rights? Fundamental rights are just some basic rights that are given to you merely because you are born as a human being. You don't have to claim this right. As soon as you are born, you are inherited with these basic rights, right? Like right to life, right to eat food, right to move freely, right? All these are the rights that you have merely because you are a human being. So what are fundamental rights? These are the rights which are essential for the existence of human beings, and they are not to be given. They are inherited as soon as you are born. These are universal in nature, inalienable. That means nobody can take away your fundamental rights from you by enacting any other provision of law. What has been given, this is the supreme law. These are the rights that have been granted, and nobody can take away your fundamental rights from you. The governments are expected to ensure that these fundamental rights are given to the citizens, and whatever has been given and enshrined in the Constitution, that they are protecting the rights of the Indian citizens. So it becomes the responsibility of the government to ensure that the fundamental rights are safeguarded and protected, and nobody is alienated or nobody's fundamental rights are taken away from them. That is the basics. So if you talk about the fundamental rights, we have 6 fundamental rights that have been provided for under the Indian Constitution under Part 3, that deals with Article 12 to Article 35 of the Constitution. We have 6 categories. I have listed down the 6 categories: right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and right to constitutional remedies. These are the 6 fundamental rights that we have. But in today's session, I have picked only one fundamental right that I am going to discuss, that is right to freedom under Article 19. Right to freedom also has various articles 19 to 22, but my specific discussion for today's session is going to be one article, that is right to freedom, Article 19. If you talk about right to freedom, like I told you, I am going to discuss 3 things: what are the rights, what are the restrictions, and what are the judicial interpretations. Before going into the actual discussion and understanding the provisions of Article 19, the first thing as students that you are required to do is understand the structure of the law. Directly don't start studying the provision. See what is provided, how it is, what is the article, what are the clauses, what are the subclauses, how many subclauses are there. Understand the structure of the law and then try to read the provisions. So under this Article 19, we have 6 clauses. Article 19 clause 1 talks about the rights. Okay, they are giving the rights under Article 19 clause 1. The rights are mentioned. Again, here we have 6 freedoms that have been granted to the citizens. Clause 2 to clause 6 are the reasonable restrictions that have been imposed on the 6 rights that have been granted to us. So like I told you, we are going to discuss the rights, we are going to discuss the restrictions, and we are going to discuss the case laws. The rights are given under Article 19(1) and the restrictions are given under 19(2) to 19(6). This is how the article is structured. We have 6 clauses. Clause 1 is the rights, clause 2 to clause 6 are reasonable restrictions. So one by one, let us look into the provisions of law. First, discussing Article 19 clause 1, that is right to freedom. Article 19 clause 1, this is the Bare Act. I have directly copied it from the Indian Constitution. It says that all the citizens shall have the right. All the citizens will have the right. What right? These 6 categories of rights. Earlier there were 7 rights, they have reduced 1 and now only 6 rights are available. The right that has been deleted is right to acquire, hold and dispose of property. This entire right was deleted via an amendment in the year 1978. Right to hold property, right to own property is still a right under Indian Constitution, but it is not a fundamental right. They have deleted as a fundamental right and retained under other provisions of the Constitution as just a right but not a fundamental right. So what are the actual 6 remaining fundamental rights that we have? I have simplified it for easy remembrance. The first one is freedom to speech and expression. Every citizen has a freedom of speech and expression that is given under Article 19(1)(a). 19(1)(b) talks about freedom of assembly, 1(c) talks about freedom of association, 1(d) talks about freedom of movement, 1(e) talks about freedom of residence, 1(f) is deleted, 1(g) talks about freedom of trade and occupation, that is G. Right? So these are the 6 fundamental freedoms that have been given to the citizens, that is freedom of speech and expression, freedom of assembly, freedom of forming association, trade unions, freedom of movement freely throughout the territory of the country, freedom to reside anywhere in the country, and freedom to carry on any kind of trade and practice any kind of occupation that you deem fit. So these are the 6 fundamental freedoms that are given to us, and each one of these we are going to discuss along with the restrictions that have been imposed on them. Now, like I told you, we have been given certain rights, but no right is absolute. We cannot give any right unconditionally, because whenever we give any kind of right, that can be misused. There can be negative or adverse impacts of the rights that have been given. Like me, there are other citizens also. Every citizen has a right. So one person's fundamental right, if it's not controlled or if it is not reasonably restricted, it can impact the right of some other individual as well. So for various reasons, with right comes a certain kind of responsibility. No right is always absolute or unconditional. Every right is subjected to certain restrictions, limitations and certain kind of control that is provided through the reasonable restrictions. So with right comes the responsibility, and nothing is absolute, it is subject to certain conditions. To prove that, we have Article 19 clause 2 to clause 6 as reasonable restrictions that have been imposed. In the same order, we have 6 rights and we have 5 categories of restrictions. Clause 2 imposes restriction on the first right, that is freedom of speech and expression. Clause 3 imposes reasonable restriction on the second right, that is right to assemble peacefully without any kind of arms and ammunitions. 4, Clause 4, 19(4) imposes reasonable restriction on the right to form association, trade unions and cooperative societies. Article 19, Clause 5 lays down reasonable restrictions on two categories of fundamental freedoms, that is to move freely and to settle or reside anywhere in the country. For so two fundamental rights, common restriction is given under Article 19(5). Clause 6 ultimately gives the restriction for the last category of fundamental right, that is reasonable restriction on carrying on any kind of occupation or profession. So this is the structure. It is very nicely organized, easy to remember and properly structured as well. Now, why is there a need for imposing restrictions on the fundamental rights? Like I said, any kind of freedom, or for that matter, any kind of right cannot be absolute. Absolute means unconditional, without limitation, without restrictions. No right can be like that, because that can have more negative and adverse impacts. So that is why we say that an absolute right is a right without any restriction, without any limitation or without any regulation. If we give you any person an absolute right, it can lead to certain consequences. And what are those consequences? First and foremost, people will misutilize the rights that have been given to them. Second one, absolute right can result in clash between individual rights. Two citizens have the same rights. In execution of one right, some other individual's rights might be impacted. So to avoid that clash between two individuals fighting for their own rights, it is necessary for us to lay down certain limitations, restrictions, and that is given under Article 19(2) to 19(6). And absolute right can endanger the sovereignty of the nation. So rights must be enjoyed responsibly with reasonable limits so as to benefit all the individuals without causing any kind of harm to the society. And with this objective, we have decided to include certain restrictions on the rights and the freedoms that have been granted under the provisions of Article 19, Clause 1. Now, whenever the right is there, we know that that can be restricted or limited by imposing certain reasonable restrictions. Now, who has the power to impose this restriction? It is only the Parliament that can impose the restriction. Through a law, restriction can be imposed. No executive order, no other person will have the power to impose these restrictions. But even when they are imposing the restriction on your fundamental right of freedoms, 6 freedoms, if they are restricting it, if they are curtailing it, if they are imposing any kind of limitations on your freedoms, that should be justified. Why are you holding somebody's fundamental right? Why are you restricting somebody's fundamental right? So, if anybody wants to impose any kind of condition or a limitation or restriction on the fundamental right, they have to pass a valid test. They have to pass a valid test. If the restriction that has been imposed passes the test that has been laid down, only then that restriction is going to be considered as valid, or else those restrictions cannot be imposed and the restriction will be held to be void. Restrictions cannot be imposed until and unless they pass the test that has been laid down by the provisions. What they say, a restriction will be held to be constitutionally valid only and only if it is imposed by the law that is going to be passed by the Parliament. It cannot be imposed by any kind of executive order. No government official by himself can impose a restriction on your fundamental right. If somebody wants to restrict your fundamental right, that is with respect to the freedom, it has to be passed through the Parliament. Only then it will be valid. Next, it has to be reasonable. There should be a reason, there should be a justification for imposing the restriction on your freedom. It cannot be arbitrary or excessive. It cannot be at the choice, it cannot be at the whims and fancies of the person who are creating the law. There should be a valid justification with the reason for imposing the restriction, and it serves a specific purpose stated under 19(2) to 19(6). So, under 19.2 to 19.6, various grounds are given on which you can curtail the freedoms that have been given. So, whatever restriction is going to be imposed on the freedom, those should come under any one of the grounds that are provided for under Article 19.2 to Article 19.6, depending upon what is the fundamental freedom that is being curtailed. So, what are the basic things? Three conditions are there. The law that restricts the fundamental freedoms should be passed by the parliament itself and not by an executive order. Whatever restriction is being laid down on or restricting your fundamental freedoms, they should be reasonable, justifiable. It cannot be arbitrary, it cannot be excessive. Third one is that whatever restriction is going to be laid on your freedom, that should fall under any one of the ground that has been specified under Article 19 sub clause 2 to clause 6. So, these are the provisions with respect to the conditions while imposing reasonable restrictions. Now, we have used the term reasonable in the second point. First one condition is that it should be made by the parliament by a provision of law. Second one, we said that whatever restriction is going to be imposed, that restriction should be reasonable. So, what is reasonable? That also is a question. What is reasonable to me may not be reasonable to you, right? Everybody has different way of analyzing things. Somebody thinks a reason is valid, I might think that reason is not valid or not justified. So, we have to give the meaning of the term reasonable from the point of view of law, and that is why we say that if you want to see whether a particular restriction that is being imposed on your freedom, whether it is reasonable or not, to check that we have an objective test that has been laid down, which says that first one, you should see what is the purpose of law. What is the purpose of law that you are passing? What is the objective that you are planning to achieve by passing a law which is curtailing the fundamental freedom? Second one, what is the urgency or seriousness of the issue? You are passing the law, you are curtailing somebody's freedom. What is the purpose behind it? What is the urgency? What is the necessity of passing it? Next, proportionality. Is the restriction too harsh for the problem that you are trying to solve by law? You know the objective. You know why you are, what is the issue in hand. On the basis of that, see what the restriction is being imposed, whether it is too harsh, whether it is required to curtail the fundamental right, whether it is required to curtail to that extent or not. Duration. Are you going to restrict the fundamental right for a temporary duration or permanently? And lastly, what is the context? What is the social or political condition when the law was made? When the law was made, what was the condition basis on which the law has been passed? These are the 5 things that are going to be questioned and seen when any law is going to restrict the freedoms that are going to be given. Now, whenever a law has been passed that is violating the provisions or restricting your freedoms, the entire responsibility shifts on the state, that is the government, to prove that the restriction is reasonable. So, okay, somebody has curtailed my fundamental freedom. I am challenging it. I am asking the court that I have fundamental freedom. Article 19 clause 1 A to G gives me 6 rights. My freedom is being curtailed by this new law that has been brought by the government. I am challenging it. So, I don't have to prove it that it is unconstitutional. The person who is imposing the reasonable restriction, he should say, he should prove that the restriction is reasonable. It is his responsibility to say whatever restriction he is imposing on my freedom, that is reasonable, that it falls under the test that has been laid down by the Supreme Court. So, the entire burden shifts upon the state, the law making authority, to prove that the restriction that has been imposed on the freedom is reasonable. If it is not reasonable, the law itself will be cancelled and held to be unconstitutional. So, the responsibility of proving the restriction to be reasonable lies upon the authority, that is the state government, state or the central. Now, what are the key principles on reasonable restrictions? First one, again it is based on the prior provisions, that it should not be excessive or arbitrary. The restriction, how much restriction are you imposing? What restriction are you imposing? Whether it is justified, whether it is not justified. It should not be arbitrary. It should not be at the choice. there should be some kind of reason. Excessive means too much. Like for example, if I say I am taking a class, all the students are requested not to use their mobile phone for 2 hours. Valid, because I want you all to concentrate in my class. But on the other hand, if I say for 2 days the students are not permitted to use their phones at all, is it valid? Is it required? When I am taking class, you are not required to use. There is some reason, there is some background for that. I want you all to concentrate on the class. That is why I am saying don't use the phone for 2 hours. That is justified. But if I say that don't use the phone for 2 hours, irrespective of whether 2 days, irrespective of whether I am taking class or I am not taking class, is that justified? Is there any reason for that? That is excessive restriction. Such excessive restriction will not work. Even if I am imposing some kind of restriction, that restriction should be needed. It should be justified. It should be valid. It should not be too much. It should not be too harsh. Okay, so no restriction can be too excessive. Neither can it be arbitrary. Arbitrary means at their own wish, choice, they are saying something. No, it should be on the basis of some reason and justification. Second one, the court assesses restrictions from the view of the public interest and not individual convenience. So whenever a reasonable restriction is going to be imposed, that restriction ultimately should be for a public good, in the public interest. It should not be for satisfying one individual person. Ultimately, we are seeing citizens together, we are seeing the entire nation as one. If restrictions are being imposed, it should be for the public good and the public morality. Even a total prohibition can be valid if it is reasonable. In the previous slide, we saw that they are going to see the duration of imposing that restriction, whether it is a temporary restriction or whether it is a permanent one. Even a permanent ban on your freedoms can be given, but it should be reasonable, it should be valid, it should satisfy all the tests that have been laid down by the provisions. So, like I said, we have 6 freedoms that are given under Article 19(1) from subclause A to G. Each one of them are very essential for humans, for the existence of human beings, and those rights come with certain responsibilities. That responsibility should be fulfilled, and that is why restrictions are imposed from Article 19(2) to 19(6), and those restrictions cannot be imposed just like that. Because freedoms are given, somebody who has authority itself will have the right to restrict those, and only if they satisfy the test and only if it is reasoned and justified. That is what we have covered till now. Let's see, it's a quick recap of how the restriction will be constitutionally valid. If a restriction is imposed by a law, only then it will be constitutionally valid. Nature of restriction, it should be reasonable, there should be a justification, it should not be at whims and fancies of people. Purpose, it must be aligning with Article 19(2) to 19(6), means various grounds are given. The restriction should fall under any one of the grounds that are specified under the article. Duration, it can either be temporary or it can be permanent in nature as well. But if it is permanent in nature, it has to also be reasonable. Why you are imposing the restriction permanently? There should be a valid and very solid reason for imposing a permanent ban on your freedom. Burden of proof is upon the state to prove that the restriction that is being imposed is reasonable in nature. And the judiciary's role, at any point in time, if there is a challenge, if some person is questioning the validity of a law, is questioning the validity of the restriction that is being imposed, then the judges are going to take the judicial view and impose the objective test that has been laid down, and then determine whether a restriction that has been imposed is reasonable or not reasonable. So, this is the test that has to be passed by the law, which is curtailing the freedom that is given under Article 19(1). Now, let's begin from here. The entire discussion is going to be interesting. We are going to discuss the 6 fundamental freedoms that are granted to us under Article 19(1) along with the reasonable restrictions. So, first let's see the freedom of speech and expression. The right that every citizen has a freedom of free speech and expression is given under Article 19(1)(a), and the reasonable restriction of the same has been imposed under 19(2). So, let's see what is the provision of 19(1)(a). 19(1)(a) says that every citizen of India has the right to freely, very important is the word free, freely express. Express what? It is freedom of speech and expression. Speech can be verbal, speech can be written, speech can be painted. In the sense, whatever expressions are there, whatever you want to say, you can say in multiple forms. You have various ways of communicating what is there in your mind, your thoughts, your ideas. So yes, every citizen in the country has a fundamental freedom of speech and expression to freely communicate and express his thoughts, his opinions and ideas. That could be in any mode. It could be by speech, verbal, by writing, by printing, through pictures, or any other mean that is going to be coming in the near future, and it includes various other rights. These inclusions have come through judicial precedents. Various rights have been brought under the ambit of freedom of free speech and expression. I'll give you an example. Now, expression can be happiness, it can be anger, it can be sadness, it could be frustration, it could be tension, and all this comes under the concept of expression. Now, when we say that a person has a fundamental freedom of free speech and expression, does that mean that a person can remain silent when he wants to? Does freedom to remain silent, right to remain silent, come under the ambit of free speech and expression? Now, for example, there are various categories of human beings. There is one person who shouts on the top of his voice when he is angry. On the other hand, there is one more category of person who goes silent when he is angry. He does not want to utter a word, and silent treatment is given. Both the category of people exist. Each individual has his or her own way of expressing. Somebody is loud, somebody is silent, somebody talks a lot, somebody does not talk a lot, somebody only observes. Every individual has his or her own way of expressing the feelings. So you cannot have a clear-cut definition of this is expression, this is not expression. That is subject to judicial interpretation, whether it is permitted or not permitted. For that, we will see various cases under the ambit of free expression. But 19(1)(a) clearly says that every citizen of India will have a right, will have a freedom to have free speech and expression. You can communicate your idea, thoughts, opinion, suggestions, criticisms openly, freely. Okay, that is the provision of law. Like I said, over the time we have a lot of cases for specifically the first category of freedom of speech and expression, where through various judicial precedents, through various cases, the court has recognized many rights that are included under the ambit of freedom of speech and expression. I have included a list here. Right to circulate. What is right to circulate? Right to circulate is, maybe you have written an article. It is your wish how you want to circulate, whether you want to publish it in a newspaper, whether you want to publish it in a magazine, whether you want to put it online on a blog. It is your choice. You have a right to decide how your content should reach the public. If you have written something, it is your choice firstly whether you want to make it available for the public or you want to keep it for yourself like a personal diary. Second one, if you want to put it out in the public domain, through what medium do you want to put it out in the public domain? That also is your choice. You have your own way of expressing yourself through article, whatever. It is your choice. The mode can also be your choice. So what is right to circulate? Right to circulate is, you cannot restrict any person from publishing the work that he has written. One case is that I will be discussing in the upcoming session. Right to dissent and right to criticize. When we are speaking, sometimes we are not happy with what is happening in and around us. We are not happy with the way the government is functioning. We are not happy with the way our institution is functioning. We are not happy with the classes that are being conducted in the colleges and schools. We are not happy with the cleanliness around us. We are not happy with so many things that take place in and around us. Now, we have a right to give our opinion. If I'm not happy, I have a right to say that no, I'm not happy, I don't agree with this. I criticize that this lake should have kept clean, but it is so dirty. It is my opinion. I am disagreeing to something. I am criticizing some work that has been done. I am criticizing the way the roads are built. They build it on one day, next day some other department comes and breaks the same road and go. There is no coordination between departments. So when I am not happy with something that is happening around me, I have a right to criticize. I have a right to disagree. And that I will do through speech and expression. I will communicate it. Only through communication I will say that I don't agree to this. So yes, when we say you have the right to free speech and expression, that does not mean you only have to tell good things. You have the right also to tell the bad things. You also have a right to tell whatever you feel is right at that point in time. So you have the right to criticize. You have the right to disagree. That comes under the ambit of free speech and expression. Next, right to portray social evils. There are so many instances of rape, sexual assault or violence that is taking place, child marriage that used to take place, a sati system that used to take place. All this were existent in India. These are all bad practices. These are all social evils, wrong practices. But we cannot shut our eye and say that it does not exist. You have to talk about it to create awareness about it. So yes, you can talk about it. You have a right to portray the social evils and communicate to the people that see, this is what is happening in our country. It is for us to stop it. But if you are not allowed to talk about those social evils itself, how will people get awareness about it? How? Right? So that is why they say that yes, whether it is a bad incident or a good incident, you have a right to portray it. If it has happened, if it is true, the facts are correct, you can portray social evils, but the way you are portraying it should be proper. Right to portray historical events. History are facts that these things has happened in the future, has happened in the past. So if you are depicting the history as it is based on evidence, nobody can stop you from depicting the history. Many people will say, why to talk about the past? For example, what happened with the movie Kashmir Files? A lot of people challenged that this movie should be banned. It is going to create unrest in the society. It is going to create, there is a possibility that violence might be there as an outcome of seeing this movie. What happened with the Kashmiri Pandits during that duration in in Kashmir, that was depicted, which was horrifying. But merely because it is bad, it was a negative incident that took place, it has a possibility that it might impact the public order in certain localities. That cannot prohibit you from not telling that story. It is a fact, it has happened. Everything is evidence is there to prove that those incidents took place. So nobody can stop you from telling that story to the public at large. So you have a right to talk about history, provided it is correct and you have facts to prove what you are showing or what you are telling with respect to the historical facts. Right to receive information. Free expression, free speech is not only you talking to somebody else, not only you expressing your ideas, it is also about what you are receiving from others. Right to information is also a fundamental right. One case I have included even from this point of view. Next, right to report court proceedings. Right to report court proceedings is a freedom of speech and expression. What are the landmark cases? What are the cases that are going on in the courts? People have a right to know about it. Recently, we saw the Kolkata law student sexual assault case. What is happening? What is the judiciary doing? What are the facts? How are we reporting those proceedings? Open justice rule is there in India. Anybody has a right to go into the court hall, sit and witness what is taking place in the courtrooms. Similarly, journalists have been given certain powers that they can report the court proceedings to the public at large. But again, there are certain restrictions that are imposed on that right. There are certain protocols that have to be followed. But that is a right of transparency. The judiciary is transparent. There is no bias, there is no favorism. So we are going to report it. But that should not be so excessive. What is happening today? Media trials. What is media trial? That before the case is ultimately decided by the judges, media has given the verdict. In Sushant Singh Rajput case also, right from the beginning, they targeted Riya Chakrabarti, that she is the one who is the ultimate person who is responsible. They had created their own version of the story. Within a few hours, they had the ultimate accused in hand. How? Without evidence, how can they say? That is media trial. So, lot of cases are there where media trial has taken place and is taking place. It is for the media to restrict itself on what is right and what is wrong. So, yes, the journalists have the right to report the court proceedings subject to certain protocol, guides, ethics, guidelines and codes that have been laid down. Right to report legislative proceedings. This was earlier there, but now we know that all the parliamentary proceedings are anyways given live telecast, except a few of them, which can be restricted. So yes, we have now direct telecast of what is happening in the parliament and state legislature. Earlier that telecast was not there. That is why journalists used to go and sit in the parliament session, see what is happening and come and report in their articles. So that right was given as expression and speech. Right to advertise. You have so many products, advertisements are there, right? That is also a way of communicating. That is nothing but commercial speech. It is called as commercial speech. Through your commercial speech, through your advertisement, you are trying to generate revenue, trying to generate your income, you are trying to sell your products and increase your revenue. So that is commercial speech which is permitted. Again, when you are advertising, a lot of other rules, restrictions are there of misleading advertisement should not be there. What is the content, what is the label of your product, n number of restrictions are there. For that, separate set of rules, regulation, laws are in place. Right to broadcast. Broadcast, television, radio, your OTT platforms, all that. It uses certain electromagnetic waves from the environment. How is it going to be? Okay, all that is covered under right to broadcast. Right to broadcast is also a way in which people are communicating, expressing. Speech is there. So that is also coming under the ambit of freedom of speech and expression. Right to silence. When a person has a right to talk, a person also has a right to determine for himself when he is going to speak and when he is not going to speak. Nobody can force another person to speak. If he wants to speak, he will speak. If he doesn't want to speak, he will not speak. It is that individual person's decision whether he wants to talk or he does not want to talk. He wants to talk to Mr. A, but he does not want to talk to Mr. B. It's absolutely his choice. He has the right to remain silent. He has the way of communicating. He has the way of expressing what he wants. He can do. He has freedom of speech and expression. And expression does not necessarily mean verbal. It need not always be communication. It can be remaining silent. It can be showing anger. It can be showing sadness. It can be showing happiness. Everything comes under the ambit of expression. I've also included a case for right to remain silent. So these are the various different categories of rights which have been included under freedom of speech and expression through various cases. Right to entertain and be entertained. Now that is the way of expressing arts, music, movies, your web series. All these are the ways in which people are communicating their thought, idea, creativity. So that is also a way of expression. Right to vote. Right to cast a vote. We are casting vote for people who we think should be elected. So we are expressing our thought, we are giving our suggestion that we want this person to be elected on our behalf. So you are expressing your interest about one person being elected. So that is a way of expressing. Casting vote is your indication that you want this person to be elected. So that comes under the ambit of expression. Right to fly the national flag. is the way of expressing your love towards the nation. So every individual in this country has the right to fly the national flag of India. Right to express beyond national boundaries. So it is not necessary that you can only communicate within India. We cannot curtail anybody from saying anything even outside the territorial boundaries of India. Freedom speech of expression not limited to territory of India, but even outside anybody can say anything. Right to conduct interviews. That also one case is there, I am going to discuss. So these are the various categories of rights that come under the ambit of free speech and expression. Now let's see what are the restrictions that have been imposed under Article 19(1)(a). 19(1)(a) is freedom of speech and expression. The restriction of that is given under 19(2). Various grounds are there. Only on these specific grounds we can curtail or restrict the freedom of speech and expression. First one is for maintaining sovereignty and integrity of India. Security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, incitement to an offence. These are the various grounds on which restrictions can be imposed on freedom of speech and expression. Let's take a few practical examples. Remember, we conducted the G20 meet in India where a lot of representatives from a lot of countries had visited India, and these were all the top people of those countries, the presidents, the prime ministers, right? Important foreign delegates had visited India. At that point of time, security was essential, protocols were essential, and to actually conduct such a big, huge international event is a huge responsibility. And whoever were involved in the execution of that meeting, if an instruction is given to them that you are not permitted to discuss any detail of what is being told to you with anyone else. I know when the US president is going to come to India, which flight he is coming, what time his flight is reaching, which destination, which airport is he going to land at, in which vehicle he is going to go to his hotel, in which vehicle he is going to come, at what time he is going to come to the venue of the meeting. All this is confidential, secret information. And when somebody has been directed that no, you are not supposed to give this information to anybody else, you are curtailing his speech. You are asking him to maintain confidentiality. You are asking him to restrict that don't tell about this to anybody else. Is it valid or not valid? It is valid because why? It is for the security. It is for maintaining friendly relations with foreign states. Suppose something wrong would have happened in that meeting. Some foreign minister would have died in India or would have been murdered in India. Who would be responsible? India as a whole would be responsible. With what face we would respond back to such an incident? How would we respond back to such an incident? So that would spoil our relations with that other country whose minister has been hit or murdered or whatever. So for maintaining security and for maintaining friendly relations with foreign state, if somebody is curtailing your speech, is curtailing that you cannot say, this is the restriction with respect to confidentiality, you cannot say, that restriction is valid, it is justified because you want to ensure that no information is leaked out, because of which there is a threat to any kind of person's life. So it is valid, right? Next, let's take one more example. All of you know Samay Raina and Ranveer Alabadia. These are online or social media influencers. They had conducted a show online and they had made one statement because of which a lot of legal consequences they had faced. They had to delete that episode. I'm not going to get into the details. You can actually Google it after it if you don't know about it and see what had happened. They had made one statement. On the basis of that statement, they have right of free communication. They can express freely their speech, expression, everything is free in the country. But it is subject to reasonable restrictions. They had made a statement which was inappropriate. It was not moral. It was not ethical. On those grounds, cases were filed that how can they make such a statement in India where we have so much values for parents and family. So a case was filed against them that they have breached public order, decency, morality. Public order, decency and morality. That their statement was not decent, it was vulgar, it was not appropriate. So yes, everybody has the right to free speech and expression, but what you are saying should not cross these boundaries that have been given through reasonable restrictions. Right? So what statements made by them came under the ambit of decency and morality. Whatever they said was not decent, was vulgar, was not suiting the Indian ethical boundaries, Indian principle boundaries, and that is why legal cases were filed against them. Next, one more case you can take for defamation. Just a practical one. I am not referring to one particular case. For example, I am saying that Mr. B is a robber. Be careful of him. He is the one who is stealing the cash from the hostel. He is the one who is responsible for all the wrongful practices which are taking within the hostel premises. I am telling this just to create a rumor in the hostel that this is a bad person, stay away from him. But what I am saying is not true. It is false. I am just saying to defame that person. In the hostel, I am making these stories, cooking up these stories. So that other person against whom I am talking, he has a right to curtail my speech. That you are making a false statement, you are making a wrong statement, this statement is not true. I am going to file a case against you. You are making statements, you are talking about me, and whatever you are talking about me is false, is incorrect, you are defaming me. Then it can be challenged. He can curtail my speech on the ground that I am defaming him. But on the other hand, if whatever I told about Mr. B, that he is a robber, he is doing all wrongful practices, he is the one who is responsible for all the evil practices that are taking place within the hostel premises, if that is true and I have evidence, he cannot say anything. Because whatever I am telling on the basis of facts, evidence. So whatever I am telling is true. I can justify myself that whatever I have said, this is the reason behind it. Then I have freedom of speech and expression. I can do so because whatever I am saying the truth. So even if it is causing a negative image of some other person, it will not impact because I have proof in hand. On that basis I am making a statement. But when I am simply telling it to somebody else for defaming that person, that is not possible. The person who is being defamed, he can question whatever I am going to say. That is defamation. You have a right to say anything, but you should not hurt any other person. You should think before you speak, right? That is the reason why on various grounds, these are the grounds, 7 grounds, 8 grounds, on the basis of which restriction can be imposed on freedom of speech and expression. Now let's look at a few case laws. Ramesh Thapar versus State of Madras. I've given the facts and the judgment, but quickly in a one-liner, two-liner, I'll explain the case to you. So what happened, this Mr. Ramesh Thapar, he was the editor of a political magazine and he named his magazine as Crossroads. So he was, because it is a political magazine, a lot of that kind of articles were published in the magazine, that is Crossroads. On the basis of the content of the magazine, the Madras government at that point in time banned the entry of the magazine for circulation in the state. They had imposed the restriction under section 9 of Madras Maintenance of Public Order Act 1949, said that if this one particular magazine, that is Crossroads, was allowed to be circulated in the state, it would cause disturbance in public order. There would be violence, there would be riots, there would be strike. Something will be not appropriate after people read the articles that are published in the Crossroads magazine. So we are banning the circulation of the magazine itself under the provision of section 9(1)(a) of Madras Maintenance of Public Order Act. So this Ramesh Thapar has challenged the validity of this provision, saying that you are curtailing my right to freedom of speech and expression My way of communicating with people is through magazine, through the articles that are being published. If you're banning my book, if you're banning my magazine, that means you're banning my freedom of speech and expression. You're curtailing my freedom of speech and expression. This entire section 9 is unconstitutional. It is restricting my freedom of speech and expression. This is not valid. It should not be permitted. And he's filed a case for violation of fundamental rights under 19(1)(a). And the Supreme Court also held that yes, the ban that has been imposed under section 9 on this magazine, it is unconstitutional. It is violating the fundamental rights under article 19(2). Because when this challenge was done, we did not have public order as one of the grounds of restriction. Security of state was there as one of the reasonable restrictions, but public order was not a ground for imposing reasonable restriction on freedom of speech and expression. And in this case, they held that one particular section, that ban that has been imposed on this magazine, that is unconstitutional, it should not be permitted. And on the basis of this case itself, the first amendment to the constitution was done in the year 1951, where they have added more restrictions under 19(2), where they have included other grounds and public order as one of the ground for imposing reasonable restriction on freedom of speech and expression. So yes, in this case, he was permitted to circulate his magazine. The ban that was imposed was removed, held to be unconstitutional. It violated his freedom of speech and expression, and ban was removed. Next. Sakal Papers Private Limited versus the Union of India. So what is this? This is a newspaper agency. The company was involved in selling of newspapers. So there was a law that was brought by the government which said that the newspaper should have certain specific number of pages, that a particular organization can print only so many number of newspapers. So the volume of printing and the number of pages that one edition can have were decided by the government. That is when the newspaper agency challenged the law itself, saying that if we have more content, if we have more news, we will publish it, no? If the event has happened today and today itself 10 events have taken place, we will report all the 10 events today. We will not give an outdated news after 2-3 days. So you cannot tell us how many number of pages are required to be printed. You cannot tell us how many number of copies we should print. Every newspaper has a different customer base. So you cannot tell us how much we should print and how many number of pages our newspaper is required to be. This is curtailing fundamental right of speech and expression. You cannot tell us how much we should communicate, what we should communicate, or how many papers we should sell. You cannot tell that. You cannot curtail the right of circulation of newspapers, and that was held to be right. They said that in this case also the freedom of speech and expression is being violated. The government has no right to interfere with the circulation of newspaper. They have no right to impose restriction on number of pages that a newspaper is going to have. So it was held to be unconstitutional, and the newspaper agency had won this case, held that their fundamental right of speech and expression is being violated. The same thing. Next. A.K. Abbas versus Union of India. So this is with respect to broadcasting, with respect to movies. He had made a short film called As a Tale of Four Cities. He was trying to depict the contrast of life. Somebody is poor, somebody is rich, somebody is having a good life, somebody is having negative social evils that they are facing, etc. So the censor board, we all know censor board will be there, film certification authorities will be there, who are going to see the movie before anybody else and tell whether a particular scene is required to be edited, cut or not. So the Central Board of Certification had actually asked Mr. Abbas to cut a lot of scenes from his short movie. At that point in time, he had challenged that I am depicting the negative aspects of the society. I am talking about the negative social evils that are existing in the society. Merely because I am talking negatively, you cannot curtail my freedom of speech and expression. That is existence. You cannot ask me to cut a scene merely because it is bad or it is depicting social evils of the society. What I am telling is true. It happens in the society society. That is why I am communicating it through my short films. So he said that cutting off those scenes which is directed by the Central Board of Film Certification is not valid. It is curtailing the freedom of speech and expression. I want to express my thought about the negatives in the society. You are not permitting me to do so by deleting those scenes. The judgment was that yes, there is violation of his freedom of speech and expression. You cannot stop a person from depicting the social evils, but the way it is being communicated has to be thought through. Even if there is a social evil that is being depicted, for example rape, for example prostitution, how you're shooting the scene is more relevant. You cannot tell them don't shoot it. You cannot tell them don't show about rape at all. Rapes are taking place, sexual assaults are taking place, prostitution is prevalent. But how you're shooting the scene is more important. We are not stopping you from doing it, but you should do it in a proper way. You should handle the situation in a proper way. So the court held that depiction of social evil as severe as rape, prostitution and the like cannot be censored. You have to tell people, you should make aware people that these are the wrong things that are taking place in the society. But what has to be seen is how the theme is handled, how the filmmaker is shooting the scene. It can be done in a decent way also. It can be done in a negative way also. So how it is being depicted on that way, we are going to say whether it should be cut or it should not be cut. If it has been shot in a very bad way and it is going to cause a negative impact in the society, we will delete that scene. But if a rape has been shown and that has been shown in a decent way, in the way it is not going to cause a negative impact on the youth, then we will permit it. So the way it is being shot is more relevant than what is being shot. It was held that it is violation of his 19(2), under 19(2) it is not required. That means his fundamental right of speech and expression was being curtailed by imposing cuts on the movie that he had shot. Next, Bijoy Emmanuel versus State of Kerala. This is a case with respect to right to silence. There were 3 students, okay. Morning national anthem, every school has this practice of singing the national anthem. So these 3 students, they were standing up, they respectfully kept their hand on their chest. They were not creating any kind of nuisance, but they were not uttering the national anthem. They were not singing the national anthem. That is when the school authorities scolded the students and said that you have to sing the national anthem. Everybody is singing, the entire crowd, all the students are singing. Why are you not singing? They said that we follow certain religious practices. We belong to a particular community and we are not permitted to recite anything apart from the book that we have, that is their religious book. Apart from that, they are not permitted to recite anything else. So we are not permitted to sing the national anthem. We are only allowed to recite or sing what is provided in our religious books. So we are not permitted to sing the national anthem, we are not going to sing. That is when it was challenged. They said that no, you have to sing. That is when the kids on their behalf, representatives filed a case saying that we have a right to remain silent. Here we are not disrespecting the national anthem. We are not causing nuisance. We are not stopping the others from singing. We are but actually respecting it. We are only not uttering it from our mouth. We are standing in the position, we are attentive, we are respecting. It is just that we are not singing. We have a right to remain silent. We can keep quiet. We need not utter the national anthem. We should respect the national anthem. It is not necessary that we should sing the national anthem. And the court also held that yes, the kids have the right to remain silent. If their religious practices don't permit them to recite anything apart from their religious books, you cannot force them to do so, and they have a right to remain silent when the national anthem is going on. This is the right to remain silent. So Constitution recognized that the way of expression is also to remain silent. You can also respect the national anthem by remaining silent. If they would have caused trouble while the national anthem is going on, okay, you hold them responsible that they are disrespecting the national anthem. But they are following everything. It is just that they are not singing it loudly. That is what the case was about. Next. Srishti School of Art, Design and Technology versus Central Board of Film Certification. Again, this is with respect to broadcast. This was one film school. they had made a movie, documentary, short movie on the demolition of the Babri Masjid. That entire story, that entire event was depicted in a certain way. The Central Board for Film Certification had asked them to delete certain scenes from the movie, short movie or the documentary that they had made, on the ground that it was historical in nature, it is based on history, and it is an event which is Hindu versus Muslim thing comes into picture. It is communal violence. Because of that, tensions might rise up in various reasons by watching your movie, so you have to delete the scenes, is what they had told. But again, the constitution here told that, the Supreme Court told that we have to uphold the constitution. You have a right to portray social history events. Whatever historical events have taken place, you can depict them, you can communicate them, but just ensure that whatever you are doing, the facts are correct. If the facts are correct, you are permitted to, allowed to depict those events. So whatever cuts and no edits were made by the certification board, that was removed, and they said that original movie as it is, which was made by them, that is permitted, because we are not going to curtail their freedom of speech and expression. They have a right to portray the historical events, they can do so. So it was held that even in this case, the Central Board of Film Certification had violated the fundamental freedom of speech and expression of that documentary. Next, People's Union for Civil Liberties versus the Union of India. So this is with respect to right to information as a fundamental right with respect to freedom of speech and expression. So we know all of us cast vote. On the basis of what do we cast vote? We see who is the candidate, what is his background, what is his educational qualification, what has he done to the society, is he a new member, how many years of political experience does he have. So many factors are there that we take into consideration before voting or giving our vote to a particular candidate. So what had happened, the government had passed an amendment to the Act. They had introduced section 33B to the Representation of People Act 1951. By an amendment, they inserted this new article which said that any candidate who wants to stand for an election need not give us information over and above what was specified specifically under the Act. We cannot ask them what is the educational background. We cannot ask them how many criminal cases you have against them. We cannot ask them what are the assets and liabilities that you have. What is your financial status? From where did you get your income? Nothing can be asked to them on the basis of the protection that was given to them under section 33B. So a lot of people challenge the validity of this section, that through right to vote, we are expressing our opinion on who should be our representative. But who should be our representative, we will decide that on the basis of the information that is given to us. What is your educational background? Do you have criminal records? What is your asset? What is your liability? What is your family background? What is your political background? N number of things are essential. But if that information is not provided to us, how will we make a decision? How will we show our expression of who should be our representative? So it was held that this one particular section 33B was unconstitutional in nature. This section was deleted by the Supreme Court, and it said that this is right to information. People who are casting vote have the right to receive this information about the candidates. Only after they get the information, they will be able to cast the vote. They will be able to express their opinion of who should be their representative. So yes, the information about the candidates is a right to freedom of speech and expression, and it should be given to the people. This entire section 33B, which restricted them from giving the information to the public at large, was held to be unconstitutional, and it was deleted from the provisions. Next, Union of India versus Naveen Jindal. This is the case with respect to flying the national flag. So generally there is a protocol that the national flag should be hoisted only on the official government buildings. On certain number of specific occasions, the flag hoisting is going to be done. Number of ways are there of how you treat and respect the national flag. What time you should hoist the flag, when it should be brought down. N number of things are there with respect to the way in which we treat the national flag. So there was this one person, Naveen Jindal, he was the member of the parliament. He also had a factory set up. He flew the national flag continuously throughout the year on his factory building. The government challenged it, saying that he as a regular citizen does not have a right to fly the national flag on a private building. He is an individual, it is a private, his factory premises is a private building. He is not permitted to hoist the national flag or even fly the national flag on his building throughout the year, because there is a certain flag code that has been established of how you should treat the national flag. The way it should be folded also is specific. Har Ghar Tiranga, you would have seen at that point in time, a lot of instructions had come with respect to how you should treat the national flag. So on that ground, they challenged that he cannot fly the national flag on his private building. That is when he challenged that I love the nation, I love my country, and one way of loving the country is respecting the national flag. I am proud of my flag. What is there if I hoist it? If I am respecting it, if I am treating it good, if I am following the protocol, if I am not disrespecting it, if I hoist it, what is the problem? If you see, every Independence Day, Republic Day, there will be small plastic flags. Small kids will hoist it. Ultimately, when the function is over, it will be fallen somewhere on the road. People are stamping and going. Is that respect? Is that the way you should treat the national flag? Whereas this person is actually respectfully flying it on his building to show the love for his country. So the challenge that the government had done, that he cannot fly the national flag, was held to be unconstitutional. He said that they cannot ban him from flying the national flag. It is his way of expressing his love for the nation, and flag code tells about how you should treat the flag, and flag code is not over and above the fundamental rights. Fundamental right is supreme. Any law comes under the fundamental rights. So by a law, you cannot restrict his fundamental right or fundamental freedoms, and it was held that he is permitted to fly the national flag. That ban that was imposed was not appropriate. It was violating his freedom of speech and expression of loving his country. So yes, every individual has the right to fly the national flag, but it should be done, most importantly, you have the right to fly the flag freely, but most important is it should be done with respect and dignity, and there is a certain protocol that has been set with respect to how you should handle the national flag. You follow that and you can do it. This was the case with respect to flying the national anthem as an expression of love, flying the national flag as in respect for your nation. It was permitted, right? So these are a few cases with respect to freedom of speech and expression. Our second right, okay, we have one more. Prabhadat versus the Union of India. So this is with respect to right of conducting interviews. So what happened, there were two prisoners, Ranga and Billa. Both of them were given death imprisonment. Okay, death sentence was given to them in the Indira Gandhi assassination case. There was this journalist, Prabhadatta, who wanted to interview Billa and Ranga. Okay, she had approached the jail authorities that I want to interview these two prisoners. Is it permitted or not? And both the prisoners, Billa and Ranga, were actually willing to give the interview. But the prison authorities rejected her application that we are not going to permit the prisoners to give interview to any newspaper or journalist or any, television media or the news channels. We are not going to permit. So the prisoners authority itself had restricted or banned that no, we are not permitting you to conduct the interview. The journalist filed a petition under Article 32 of the Constitution, that is the safeguarding writ petition to safeguard your freedom, fundamental rights, said that I have a right to talk to anybody, I have a right to ask questions, I have a right to conduct the interviews. Why are the jail authorities not permitting me to conduct the interviews? What is the ground for restricting? There is no reason that they gave of why they are not permitting for conducting the interview. No reason was given. Randomly, they just said arbitrarily, no, we are not going to permit. She challenged it before the Supreme Court by filing a writ petition that I want to conduct the interview. The prisoners are ready to give me the interview. Only the jail authorities are not permitting me. On what ground, even I don't know. So it was held that the fundamental right of freedom of speech and expression was being violated in this particular case, she should be permitted to conduct the interview, but there is a protocol of conducting the interview of prisoners. A jail manual will be there. There is a protocol in which you have to conduct the interview. The prisoners cannot be permitted to come outside. Whatever interview is there or whatever telecast you want to do, you should do it within the jail premises. That setup should be done. An number of conditions and restrictions are there. You follow the jail manual, you take the authorities' permission, and you can go. So it was held that journalist has a right to conduct the interview even of the prisoners only on the condition that the prisoners, they should be willing to give the interview. You cannot force them to give the interview. If the persons whom interview you want to take, that person is ready, and you're following all the protocol principle that is being written in the jail manual, we have no problem, you can conduct the interview. It was held that the ban or the restriction or the rejection order that was given by the prisoners or the police authorities, that was held to be not valid. The prison authorities, they rejected the request of conducting the interview. That order itself was unconstitutional. The journalist as well as Billa and Ranga's fundamental freedom of speech and expression was being violated. By this case itself, we have brought the right to conduct interview under the ambit of freedom of speech and expression. Okay, so that was all about the first category, which is very, very essential. If we talk about freedom of speech and expression itself, we can go on for hours together, but I've restricted to a few major cases. Let's move to our second freedom, that is freedom of assembly. Article 19(1)(b), that is the second one, talks about freedom of assembly, and the restriction is given under clause 3. So what does it say? It just say that people can assemble in a public place. People can gather together. They can form an assembly. They can assemble. They can form a gathering. They can meet. But the condition is they should meet without any arms. Means you should not have any weapons, guns, and any kind of ammunitions. You meet happily. You meet gathering. If you want, like, if something wrong happens, people take out a candlelight march. That is also people are assembling for some reason. People are gathering for some reason, right? A lot of candlelight marches we have seen in the past. Nirbhaya gang rape case, a number of, whenever people are not happy with some event, if they want to show some kind of retaliation against what is happening, they take out, they are sad, they are grieving for the peace of some person, they take out a candlelight march. People are assembling in huge numbers, lakhs together. They are permitted to. You cannot ask them, no, you cannot conduct this candlelight march. No, you cannot meet. You cannot meet in a public place. You cannot block the roads. They cannot do so. You have a fundamental right. You have a freedom of assembling anywhere you want in a public place. But the only condition is it should not be with the arms. You cannot carry any kind of weapons. It should not be violent. Peacefully you can assemble. Peacefully, without causing any trouble to other public. Without causing any kind of trouble to the government. Without causing any trouble to the public properties. You can conduct your strike, you can conduct your march, you can conduct your candlelight march, whatever you want you can do. You can assemble, you can gather, but it should be peaceful. It should not be with any kind of weapons, right? That is what is being told under Article 19(1)(b). Every citizen has a right to assemble peacefully and without any arms. So two conditions are there, which I have already told you. You can assemble, you can gather, but it should only be for in a peaceful manner, and second one, you should not carry any weapons. If these two conditions are satisfied, nobody can stop you from gathering or assembling. But if you are causing violence, if you are not listening to them, if you are causing trouble, they will come and curtail your right, because you are also not following the right. The right is specific. You can assemble, but in the right itself, they are given you two conditions. It should be peaceful and it should not be with any kind of weapons. If you are carrying weapons and you are assembling, they have a right to question you. Then they are not restricting your fundamental right. What is the importance of this? This is going to support democracy. Like India is a democratic country. You have a right to say whatever you want, even if it is against the government. Even if you're not happy with the way the government is functioning, you have a right to give out your opinion, right? So you have a right to conduct strike. It is permitted. it is going to allow people to express, to discuss and spread ideas, anything related to public issue, more so with respect to public issue. So that is the important, it is going to uphold the democracy because people can come together and talk against what is not happening in the public good. Next, the two conditions, like I already told you, the right comes with two conditions, that it should be in a peaceful manner and it should be without any kind of arms. If these two conditions are satisfied and you're gathering and assembling, nobody can stop you. What are the reasonable restrictions that are imposed on this right of assembly? First one is sovereignty and integrity of India and public order. We can curtail your right of assembly if it is going to impact the sovereignty and integrity of the country. If you are assembling for some reason which is going to impact the public order, it is going to cause some kind of unrest in the society, it is going to cause some kind of violence or some kind of strikes, some kind of damage to public properties, all of that, if there is a possibility that your assembly, your gathering can lead to any one of these, is going to impact any one of these, then we have a right to restricting your right to assemble. A few cases. Kameshwar Prasad and others versus the state of Bihar. So the Bihar government had introduced a new provision by the way of an amendment. Rule 4A was introduced under the Government Servants Conduct Rules 1956, which clearly said that any government employee of state of Bihar, they were not permitted to conduct any kind of strike or any kind of assembly with respect to the conditions of service. They were not permitted to challenge their conditions of service. They could not meet, they cannot demonstrate any kind of strike in relation to the way of service, conditions of service. This, one of the employee, one of the government servant along with others, okay, one person along with others together, they challenged this rule that was introduced by the Bihar government, saying that it is unconstitutional. You cannot stop us from striking, you cannot stop us from demonstrating our displeasure with respect to the conditions of service, conditions of employment, terms and conditions of employment. And they challenged that this entire rule 4A was unconstitutional because it is violating our fundamental right of assembly, meeting whenever we want peacefully. That was curtailed. So it was held that yes, this total ban on demonstrations and strikes with respect to service of employment or conditions of employment was struck down and held to be unconstitutional. The imposition that was or restriction that was imposed by a rule 4A was not a reasonable restriction. It cannot be considered. It failed the test of reasonableness and it was held to be unconstitutional. That was deleted later on. Next, Himmat Lal K. Shah versus the Commissioner of Police, Ahmedabad. So what had happened here? Under the Bombay Police Act, certain blanket permissions were given to the police authorities that at any point in time, they have the permission to prohibit any public meeting or any kind of procession without any kind of guidelines, without any kind of criteria, without any kind of safeguards. Blanket ban, blanket permission was given to them, that entire thing is in your hand. If you want to permit, you permit. If you don't want to permit, don't permit. No criteria was there, no guidelines were there, no rules were there. They just said that if you're not happy with the public meeting, you can stop it. That much power was given to the police authorities, and that is when this person filed a case saying that this one particular rule that is given so much power in the hands of the police authorities is not valid. It is violating our right of assembly. Who are they to stop us from meeting in a public place? Who are they to stop us from conducting some kind of procession? And that too without any defined criteria, on just arbitrary grounds. So it was held that this power that was given to the police authorities under the Bombay Police Act was unconstitutional and not permitted. Only if it is for reasons that are reasonable, it is permitted. If it is for interest of public, it can be permitted. But like this, given a blanket prohibitions cannot be permitted, and it was held that it has to be modified. The police authorities cannot have the right to impose blanket prohibitions. Third category of right is freedom to form associations. associations, cooperative society, trust. You have trade unions. All of these is where people come together, and at any point in time, if they have any kind of issue, they raise their voice. So that is the right. 19(1)(c) talks about the freedom to form associations, and 19 clause 4 imposes the reasonable restriction. So it says that every citizen has a freedom to form any association, form any unions, that could be trade unions, form any group for the purpose of holding meetings or taking out peacefully any kind of procession, again without any kind of arms. Okay. This allows the people to unite for a common cause and shared beliefs. People of the same beliefs or people who are in the same organization, they can form their unions, they can form their associations, and they can meet whenever they want, and they can promote whatever is their objective, their will. Importance is collective voice and action. Taking the example of trade union. Trade union is generally of employees, labor. If they are not happy with something, they can talk to the trade unions and conduct the respective strike. So that is collectively all the labor together are striking against the company because they are not happy with the terms and services. So if you are permitting the creation of the trade union, you are permitted to form, you are permitted to start a new association, you are permitted to start a new trade union or any kind of union, any kind of group where you have a common objective to achieve. Trade union, student group, political parties, all of this comes under the ambit of forming assembly and strengthening democratic participation. So associations, union, any kind of group, anything you can do. You have a right to start your own party, you have a right to have your own association, own trade union, own group of people. But the only thing is, all of them people who are joining your association will have a common objective, will have a common goal. Okay, so that is permitted under this particular clause. What are the restrictions? Again, the same restrictions. If your association, if your trade union, or if your group, or if your party is going to do anything that is against the sovereignty or integrity of our country, we have a right to impose restriction on the formation of your association. Anything that is going to impact the public order, it is going to cause violence, it is going to cause negative impact in the public, it is going to cause some kind of unrest in the society, then we have a right to impose a restriction on the formation of your association, trade union or group. Morality, moral grounds, ethical values. If your association's objective is not ethical, it is not moral, we have a right to cancel the registration of your association. So these are the three grounds only on which the objection or restriction can be imposed with respect to formation of any kind of association, group or trade unions. Student unions as well. Let's look at a few cases. Damayanti versus the Union of India. Okay, so there was one organization, Hindi Sahitya Sammelan. Okay, it was established in the year 1910 as a voluntary organization, and it was an autonomous organization. Okay, members and governance were there, membership were there, leadership were there, it was going on. But one point of time, the people who were running this association, they had internal disputes among themselves, and the case was in the court. Hindi Sahitya Sammelan, 1910 it was formed. Over the years it was running very well. The internal disputes took place. The case the trouble landed up in the court. Okay, court case was filed. At that point in time, to solve the issue, the UP legislature passed one law called as Hindi Sahitya Sammelan Act of 1963 to give a statutory recognition to this authority. This association that was formed, they wanted to make it a statutory body, statutory authority. So they passed this enactment, Hindi Sahitya Sammelan Act of 1963, which was fine. What went wrong is with the law. In the law, they mentioned that without restriction, any person was permitted to be added as a new member without the consent of anybody, without the consent of the founding members, without the consent of the current management and ownership, whoever had, because association or a group is run by a selected people. A few people are in the management of the association. Without asking the management, also powers were given to add new members. Okay. Against the will of the founding members, also new members can be added, and total ownership of the society's assets was transferred to the new entity, that is the statutory authority. That is when they challenged that this entire enactment was unconstitutional, because we have a right to form an association. When a group of 10 people have formed an association, what is happening in that association should be totally their choice. They are the founding members. They know what is the objective or what is the goal with which they started an association. They have pooled in the money for that association and they want to achieve some objective. Suddenly a third person is coming and saying, we will decide who will be the member, we will decide how to use that money. Who will listen? So they said that along with the right of permission to create association, you also have a right to run the association without any kind of interruption from anybody else. So it was held that the protocol of adding new members and transfer of ownership, both are not valid, it is unconstitutional, and the opinion or suggestion of the founding members should be taken before adding any kind of new members. So it was held that Supreme Court struck down the entire act, holding that it is violative of the right to form association, because they only don't have the right to form the association, but along with that they have the right to continue the association with the self-selected members, with the founding members. They know the true objective of forming that association. A third person cannot intervene of who should be members, who should not be the members. So it was held that this law, that is the Hindi Sahitya Sammelan Act of 1963, with respect to adding members without consenting the founding members, was unconstitutional. You have the right to form association. Along with that, you also have a right to continue the association with the founding members, and their decision shall be final. Next, All India Bank Employees Association versus the National Industrial Tribunal. So again, this All India Bank Employees Association was established to represent the entire employees who were working in the banking sector. So collective interest of all the employees of the banking sector, they want to represent through this particular association, that is All India Bank Employees Association. They were created for a particular objective, for collectively taking responsibility of every employee, but over the period of time they were not fulfilling the objective. They were not achieving the objectives for which that association was formed. When they were not performing up to the mark, when the association was dormant, they were not doing a lot of work. That point in time, a lot of people tried to deregister that association. They tried to restrict the activities of the association on the ground that they are not performing well, that they are not fulfilling the objectives for which they were formed, or that association is not performing well, it is dormant, it is not functioning at all. They try to deregister the association. That is when the All India Bank Employees Association challenged the deregistration, challenged the restrictions that were imposed on them, said that it is infringing their right to form association. Nobody can tell us when we should dissolve our association. Unless and until we are not causing any kind of trouble, why are you imposing this restriction on us? And the Supreme Court also said that yes, it does not, here we are not seeing whether a society has achieved its objective or not, whether it is successful, it is not successful. All that is not our relevance. Our relevance is the society is registered, association is registered. It is absolutely fine. You should permit them to operate the way they want to operate, and you cannot ban them, you cannot disband or restrict them solely because they are not performing well. You can restrict a association only on 3 grounds that we saw: sovereignty, integrity, public order and morality. Only on these 3 grounds you can cancel the registration of the association, but here they are not performing, or they are dormant, or they are not efficient enough. That does not come under any one of the criteria that is given under 19(4). So on what ground are you deregistering them? So the deregistration order was held to be unconstitutional. It was permitted that the All India Bank Employees Association should continue the way it is, and nobody can deregister that association. So they have a right to continue. Next, 4th category of our next freedom is freedom of movement, freedom to move freely. Nobody can tell you that sit here, don't go there, don't step outside of your house, don't travel to other state, don't go here, don't go there. Nobody can tell you. It is your choice. You have a right to free movement, and that is given under 19(1)(d), and the restriction is given under 19(5). What does the provision say? It says that every citizen has a right to move freely throughout the territory of India. Freely throughout the territory of India. Now, if you want to travel in India, do you need passport? Do you need Aadhaar? Do you need your PAN? No, it is your choice. Wherever you want to go on a vacation within the territory of the country, you can just book a ticket and go. No documentation, no visa, no additional licensing, registration, all that is not required because territory of India is as a whole. Wherever you want to travel, you can go. Wherever you want to go and see the places, you can do so. Wherever you want to take a vacation, you can take a vacation. There is no restriction that is imposed. Somebody who is in Punjab can come to Karnataka. Somebody who is in Tamil Nadu can go to West Bengal. Does not make a difference. So they say that you have a right to free movement throughout the territory of India. You can move freely. Nobody is going to question you. That is with respect to movement. Okay. But this does not include the right to go abroad, because if you want to cross the territorial boundaries of the country, you will require a passport, you will require the visa of the country in which you are going. That does not qualify under this. Here we are talking only about movement within India. If you want to move outside India, Article 21 is there. Right to life and personal liberty, under that we have provisions, under that we can interpret the law. But under 19(1)(d) with respect to right to free movement, it is only and only within the territory of India, not beyond the territory of India. So nobody can stop you from moving anywhere through the country. The restrictions are in the interest of the general public and for the protection of the interest of scheduled tribes. Now, what are these two restrictions and why are they important? And these are different from any restriction that we saw in the previous reasonable restrictions. These two restrictions are coming for the first time. One is in the interest of general public. If one person, he is of criminal nature, he has been doing a lot of crimes, but he's absconding. Basically, he's not come under the catch of the police officers. He is moving freely throughout the territory because that is his fundamental right. But his presence in a public place can cause an impact on the general public. Okay, at that point in time, we have a right to catch hold of that criminal and put him behind the bars. So, if any point in time, any person is going to cause any trouble to the general public, his right to free movement can be curtailed. We can catch hold of him and put him behind the bars. We can restrict his movement from one place to the other place. Next, for the protection of interest of scheduled tribes. So, there are a lot of tribal communities in India. They have restricted areas. They live in the forest. They live in a certain way. They have a certain way of living. You cannot be, as regular people, regular citizens who do not belong to those tribes, we cannot go to those tribal areas. We can go and talk to them if they permit. A lot of tribes are not even open to communicating with the other people. Right? We cannot go and reside in the tribal area without the permission of those tribal authorities or the people belonging to the tribal group. So, that restriction is there. You can travel anywhere, but you cannot cause any kind of disrespect or any kind of inconvenience to the tribal people, because they are residing in the forest. You cannot cause any kind of impact to them. That area is protected. Scheduled tribes are there. So, those tribal area is protected by law. So, in those protected areas you cannot go. In all other places you can move freely. So, for these two reasons only we can impose restriction on movement. If you are causing any kind of trouble to the general public, your movement will be curtailed, and for protecting the scheduled tribes, we will not permit you to go to their area. These are the restrictions that are imposed on the right to free movement. Let's look at a case. N.B. Khare versus State of Delhi. This person, Dr. N.B. Khare, was a president of All India Hindu Mahasabha. For some reason, under the East Punjab Public Safety Act, they had passed an order that this one person should leave Delhi and go, and he should not come back to Delhi for at least a duration of 3 months. They restricted his travel, saying that you're in Delhi, you leave Delhi and go. For 3 months, you're not allowed to step inside the territorial boundaries of Delhi. They imposed restriction on his entry into the state in Delhi. He challenged that you are restricting my movement. Who are you to tell me where I should go, where I should not go? You are violating my freedom of movement. Whenever I want to go to Delhi, I'll go. When I want to go to Gujarat, I will go. Who are you to tell me when to come, when not to come? You are violating my right to movement. You cannot do so. Your order banning my entry into Delhi for 3 months is invalid. It is unconstitutional, is what he said. He challenged that before the court of law. And the Supreme Court said that this order that has been passed directing that person who was the head or president of the All India Hindu Mahasabha, for some reason for which there was justification, the order has been passed. So, seeing the facts and circumstances of the case, the order of restricting his entry into Delhi for 3 months was reasonable and justified, and that is why they said that the order was not unconstitutional. On some kind of communication of grounds of review mechanism, it was held that it satisfies the test of reasonable as laid down, and this is not unconstitutional because the order was passed on the basis of some reasonableness and it was held not to be violating the fundamental right. So, in this case, this is the first case that we have discussed in so far where it was not violating his fundamental right, a wrong challenge was done. Next, fifth right is freedom of residence. It is slightly in hand with free movement. 19(1)(e) talks about residence and the restriction is same. For right to free movement and right to freely residing in any place, for both the restriction is given under the same clause, that is clause 5. The right is under 19(1)(e). What do they say? Every citizen of India has a right to reside and settle in any part of the territory of India. You can decide where you want to settle. You are born and brought up in Kerala, but you have got a job somewhere in, let's say, Bombay, Mumbai. You want to move, you want to take your residence there, you want to stay in Mumbai, you want to settle in Mumbai, it's your choice. Nobody is going to ask you why. Right? So, that is the right of residence. Throughout the territory of India, wherever you want, you can settle. Wherever you want to reside, you can reside. Wherever you want to build a house, you can build a house. There is no restriction. There is a direct correlation between 19(1)(e) and 19(1)(d), that is right to free movement and right to residence. Both are correlated, both are similar. It overlaps the right of free movement. It is created for satisfying two things. We are aiming at two things. One is removal of any internal barriers. We don't want to divide our country on the basis of states. We want the unity of India to remain. We don't want our country to be known as Tamil Nadu, Kerala, Karnataka. No, India is India. India should be the top thing. We want unity in our country. We do not want south, east, north, west. We don't want people to fight amongst each other, Tamil versus Kerala, Tamil versus Karnataka, north versus south. We don't want that. We want unity for our country and we don't want any kind of internal barriers. Okay, that is why we have given free movement and allow free movement and settlement anywhere in India. Move freely, settle anywhere you want. There is no restrictions, there are no permissions, there are no licenses, there are no registrations. You can build your house, you can stay, you can move wherever you want to. Restrictions are on the same for the general public's interest and for protecting the scheduled tribes. So, you cannot build a house or you cannot reside in a tribal area, okay, because that zone is protected and preserved and reserved only for scheduled tribes. Only they can reside in that particular protected area. And in the interest of general public, if you are causing some inconvenience by settling or residing in some place, the localites, your neighbors are not happy with your behavior, then they have a right of restriction because you are causing some kind of trouble to the general public who is residing in and around your locality. If they have a problem with you, they can question. And if it is reasonable, we can ask you to move out of that particular place. So, for general public interest and for the protection of scheduled tribes, only we can restrict your right to movement and your right to residence. Next, two cases are there, state of UP versus Kaushalya. This is a case with respect to the residence of prostitutes. So, there was this one particular section, section 20 of the Suppression of Immoral Traffic in Women and Girls Act of 1956. Under that, an order was passed where certain group of prostitutes were asked to vacate a premises. They were living in a area where they were asked to vacate that place and a show cause notice was issued to them. You tell us why we should not ask you to leave this place and reside somewhere else. Why you are not permitted to carry on the activity of prostitution in this particular area. Okay, they had passed an order that they should vacate that place and go. They are not permitted to continue residing in that particular place. So, the group of prostitutes challenged the decision of the magistrate, asking them to vacate the premises, saying that we have a right of free residence, we have a right to move freely under 1E. You cannot question us, it is violating a fundamental right. But again, it was held that it did not violate their rights. It is for public order and morality. Yes, we know prostitution persists, but it should be in certain area that is not causing any kind of impact to the general public, not causing any kind of morality issues. So yes, they have specific areas and they should be in those areas. If there is some area that is not suitable for them, they can be asked to vacate the place. So it was held that whatever order or the restriction was imposed on them, it did not violate the fundamental rights that were granted to them. It was held that they had to vacate that premises on the grounds of public order and morality. We didn't say that you are not permitted to stay here. On the grounds of morality, on the grounds of public order, to maintain certain environment in a locality, they were asked to vacate. That is all. There is no other intention behind passing that order. So it was held that no, it is not violative of their fundamental rights. Next. Ibrahim Wazir versus State of Bombay. So there were India-Pakistan partition took place. A lot of people from India went to Pakistan. A lot of people from Pakistan had come to India. At that point in time, a lot of people were residing in India. They called themselves as Indian citizens. Okay, but the government passed an order that a few people should go back to Pakistan. A few people should go back to Pakistan under the provisions of Section 7 of Influx from Pakistan Control Act of 1949, and without any specific reason or anything, they said that these are the people who have to go back to Pakistan. They are not permitted to continue their residence in India. This section and this provision was questioned by a few citizens who were citizens of India. They said that you are violating our right to residence. We have a right to reside in the country wherever we want. That is the provision that has been laid down. Free residence throughout the country of India, throughout the territory of India. We can live wherever we want to. How can you ask us to leave the country and go? You are violating our fundamental right. They challenged the Section 7 of Influx from Pakistan Control Act of 1949. The Supreme Court held that yes, there is Section 7, okay, it is for protecting the security of the country, but if it is applied to Indian citizens, it is unconstitutional. You cannot ask an Indian citizens to leave the country and go. It is unconstitutional to the extent that it is imposing restrictions on the Indian citizens itself. They have a right to free residence. They are permitted to do so. It is violative of the provisions. Any Indian citizen has a right to reside as well as settle wherever they want, and this arbitrarily asking them to go and leave the country is not valid and justified. So that Section 7 cannot apply to Indian citizens. It can apply to anybody else, but not to Indian citizens. So it was held that that section is violative of their fundamental right to settle and to reside in India. Next, last one is the freedom to trade and carry on any kind of occupation. 19(1)(g). Before this, 19(1)(f) was there, right to hold, acquire property, but that has been deleted. So the sixth right is right to trade and occupation, and the restriction is given under 19(6). What are the provisions? It says that every citizen has a right to practice any profession that he wants, has a right to carry on any occupation, any trade or any business that he decides. It is your choice whether you want to do business, whether you want to do retail business, wholesale business, whether you want to do electronic business, you want to do fast moving commodities, whether you want to sell vegetables, fruits, whether you want to be a farmer, doctor, engineer, doctor, CS, CA. It's absolutely your choice. It is your right to decide where you want to build your career, what you want to do. You want to enter a profession, you want to enter a business. Whether you want to become a trade person, you want to become a farmer. It's your choice. It's your right to decide what you want to do, and nobody can question that. The key concept explained, the words have been explained. Profession means lawyer, doctor, some qualification based education. Some kind of skill is required to carry on a profession. Trade means merely buying and selling, like retailer. Retailer is buying from the wholesaler, selling for consumer. There is not much skill that is going to be involved. Business is wider term. It includes a lot of commercial activities, and occupation is any regular work or job. What is your occupation? Any service. What are you doing? Whether you're a businessman, tradesman, that is the occupation. Farmer, agriculturalist, all that comes under occupation. So these are the various terms. It is your choice what you want to do, what interests you, but reasonable restrictions can be imposed on certain grounds. First one, in the interest of general public. Second one, prescribing professional or technical qualifications. And third one, allowing the state to carry on any trade, excluding other regular citizens to carry on. This is nothing but monopoly. What is monopoly? That there are certain things, like for example, railways. There is no private player, no, in railways. It is a monopoly that only state has the power to run the railways. That is the business that only the government is involved in. There is no private entity working in the railway sector, right? So that is, they can impose restriction that only government will be permitted to carry on this business, nobody else is going to be permitted. That restriction can be imposed. Second restriction is on the basis of technical qualification. Suppose there is a doctor, he knows nothing about law. Can he become a lawyer? Can he practice before the court? Can he appear before the judges? Or I am a lawyer, I am a company secretary by profession. Can I go and conduct some surgery? Should I be permitted to? Can I become a doctor? No, for certain professions, you need certain educational qualification, you need certain certification. Only after you become that, you are permitted to carry on the thing. You are a company secretary student, but can you sign as a CS merely because you are a CS student? No, you need to qualify the exam to sign that document. That qualification is required. Without the qualification, you are not permitted to carry on that profession. So yes, on the basis of qualification, educational requirement, some skill that you require, on the basis of that, restrictions can be imposed, and in the interest of general public. On these three grounds, restrictions can be imposed on people from carrying on certain trade or activity. Let's look at a few cases. Chintaman Rao versus the state of MP. So what happened? There were a lot of villages in which they were manufacturing BDs. Okay. So the government, state government, brought a rule that in the prime agricultural season, that is the harvesting season, all the BD manufacturing units should shut down. They said that during the agricultural season, the manufacture of BDs is prohibited. The reason behind that was they wanted the entire labor, anybody who is there in the state, to work on the agricultural fields. They wanted more people in the agricultural sector. They did not want people to work in the BD manufacturing units in the agricultural season. If it is not agricultural season, they were permitted to work wherever they want. This was challenged by the BD manufacturing unit. Okay, the person who was the manufacturer of BDs, he said that only non-agricultural season, my business is running. On other durations, when agricultural season is there, you are impacting my business. You are not allowing me to carry on my business of manufacturing my BDs. Because labor is not permitted to work in the manufacturing of BD unit at all. Okay, if there is youth who is working in agricultural grounds, okay. Old people who cannot go to agricultural lands and do physical work, even they were not permitted to manufacture BDs. Small children, in the sense above the age as laid down in Factories Act, but that time Factories Act was not there. So even children were not permitted. Women were not permitted. So even people who are not entitled or not capable enough of working in agricultural fields, even those category of people were not permitted to manufacture BD in the agricultural season. This was challenged in the court that the state government cannot impose this restriction that during agricultural season the BD manufacturing cannot take place. They challenged that it violated his fundamental right of carrying on any kind of trade and business. It was held that it is unreasonable restriction and it affected the non-agricultural person like women and elderly people who could make money by manufacturing beedis in the agricultural season. Even their source of revenue had gone because of this restriction. So it was held that this restriction that was imposed by the state government is inappropriate, is unconstitutional, and it is violating the manufacturing of beedi sector of their fundamental right of carrying on any kind of trade and occupation. Next, PA Inamdar versus the state of Maharashtra. He was running a group of private unaided means totally private, not government aided, 100% owned private funds. He was running educational institutions for the minority sector. Lot of group of educational institutions were there. So when it is a private institution which is not aided by the government, all the rules, regulations can be made by the private entities. The government is not allowed to interfere with the activities. So they said that the Maharashtra, the government imposed a policy saying that a common entrance test and reservation quota as applicable to the other institutions will also become applicable to this private unaided minority group of educational institutions. So they said that state government's policy on reservation, state government's policy with respect to the common entrance test, all that should also be followed by this minority educational group. It should become applicable is what they are saying, but this was challenged by the founder of that group or that organization, saying that it is a private entity. We are not taking even 1 rupee from the government. It is an unaided institution. It is a minority institution. How we run our organization, what we do, all that we will take care. The rules of the government will not become applicable to us with respect to reservation criteria and with respect to the entrance test. So it was held that autonomy of this private unaided education institution should be upheld. This restriction or directing the state's policy to directly become applicable to the educational institution is not valid, but that does not mean that these educational institutions which are private in nature are not regulated at all. They should be regulated, but the state government's policy will directly not become applicable to them. They have an autonomy, they can decide for themselves, but we can create an authority for regulating body should be created for monitoring the admissions, how fee structure is done. For all that, one separate regulatory authority can be created to monitor the private educational institutions, but direct state government educational policies of the government institutions cannot be applied to private institutions. It is violating their right to conduct trade and business. This was one more case. A quick recap of entire Article 19. In a short duration of time, I have tried to sum up the 6 fundamental freedoms that we have, along with the reasonable restrictions that have been imposed on them and certain judicial interpretations. So first one is Article 19(1)(a), which gives every citizen the freedom of speech and expression. The reasonable restrictions on freedom of speech and expression has been laid down under 19(2) on 8 grounds that we have seen. Next freedom, second freedom is the 19(1)(b), that is right to assemble peacefully and without any kind of arms and ammunitions. The reasonable restriction is given under 19(3), which is for 2 reasons: sovereignty and integrity of the nation and public order. The third category of freedom that we saw was the right to form association, trade union groups, etc. And the restriction is given under 19(4) for 3 reasons: sovereignty, integrity of the nation, public order and morality. Our fourth category of freedom was 19(1)(d), that is right to free movement throughout the territory of India, and the fifth category is 19(1)(e), right to reside and settle anywhere in India. Both these rights are correlated to each other, and that is why reasonable restriction for both these rights are given under the same Article 19(5), which is again on 2 grounds, that is interest of general public and for protecting the scheduled tribes. And the last category of right, 19(1)(g), is the right to practice any kind of profession and carry on any occupation, trade or a business, and the restrictions are: first one, in the interest of general public; second one, for educational qualifications or technical qualifications; and lastly, for the monopoly of state. If a state has or the government has decided one activity should be carried on only by the government and no private players are permitted, that business can be carried out only by the state, and that will not restrict their freedom of carrying on any trade and occupation. So this was a quick summary of Article 19, where we have seen the rights, we have seen the restrictions, and we have seen how the courts have interpreted the provisions of 19 and various category of these rights. So with that, I would like to end the session on Article 19. I will see you all in the next session. Till then, keep learning and keep growing. If you all want more such sessions, we have upcoming batch. For more details of the batch, you can contact us on 973-973-3400 for more details. Till then, study well.